Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 38th year of free enterprise, public interest law advocacy, and educational work. We are very, very active each year in the U.S. Supreme Court. So far this term, we have filed briefs in 4 of the pending cases, the 3 class action-oriented cases that Tom Hungar is going to address, as well as the DirecTV case involving arbitration. We also have cert petitions, amicus briefs in a number of cases that were potentially decided on this last Monday, yet to be announced. The R.J. Reynolds case involving extraterritorial application of RICO, Quicken Loans case involving punitive damages, and a third one, another class action case involving Dow Chemical. We will be certainly following the court during the term, and if there's anyone out there who is looking for comments on any of the cases that we file in, we are always happy to entertain them. I want to introduce the panel of speakers that we'll be having today in the order in which they're going to speak. Speaking first will be Christopher Bartolomucci, who's a partner with the law firm Bancroft, PLLC. Mr. Bartolomucci's practice focuses on appellate and complex litigation. His government service includes experience in every branch of the federal government, including at the White House as Associate Counsel to the President, 2001 and 2003. Served as in the Office of the Solicitor General of the U.S. Justice Department, and also clerk for Judge William Garwood of the U.S. Court of Appeals for the Fifth Circuit. Following Chris will be Linda Coberly, who is a partner in Winston and Strawn's litigation practice and chairs the firm's appellate and critical motions practice. She served as a law clerk to Justice Stephen Breyer on the U.S. Supreme Court and to Judge Doug Ginsburg on the D.C. Circuit. She's been recognized by the publishers of Chicago Magazine as an Illinois super lawyer in the area of appellate practice for each of the last 10 years. Finishing up today will be Thomas Hungar, who's a partner here in Washington with Gibson, Dunn, and Crutcher, where he co-chairs the appellate and constitutional law practice groups. Mr. Hungar previously served as Deputy Solicitor General of the United States. He also was a law clerk to Judge and Justice Anthony Kennedy and Judge Alex Kaczynski on the Ninth Circuit. In addition to our audience here in person, we'll be taking questions at the end of the program from our online audience. If you can email us at interactive@wlf.org, we will present the questions to the various speakers. Chris, if you could get us started.
Well, thank you, Glenn, and thank you to the Washington Legal Foundation for hosting this panel today. In Washington, D.C., and especially in the legal community, nothing heralds the arrival of fall quite like the Supreme Court term preview panel. So I'm very pleased to be here and to be with such distinguished advocates as Linda and Tom. So I'm going to talk about several cases, 4 cases, one of which the Supreme Court has already agreed to decide this term, and the others of which are in the pipeline and seem fairly likely to go to the Supreme Court, and we'll find that out in the coming days. The first case I want to address is the case pitting the Vermont Green Mountain Care Board and the Liberty Mutual Insurance Company. This case concerns Vermont's health care database law. And the case is about the division of proper authority between the states and the federal government over the regulation of health care. And it's also a case that involves the doctrine of preemption. And that doctrine, preemption, is the name for the doctrine that when a state law conflicts or undermines a federal law, the state law has to give way. It's nullified by the federal law. This doctrine derives from the supremacy clause of the Constitution, which makes federal law the supreme law of the land. So when a federal law and a state statute come into conflict and butt heads, the rule is the federal statute wins. So this case, the state statute here is the Vermont Healthcare Database Statute, which requires insurance companies and others in the healthcare industry to provide to the Vermont government data on healthcare claims and other healthcare information. Vermont collects this data and information and puts it into a database that it calls the United Healthcare Database. Now, according to Vermont, they use this database to inform and improve its policymaking with respect to health care. Vermont says, we take steps to preserve the privacy of the individuals involved, but that the collection of this information into a database allows it to understand the cost, quality, and utilization of health care for its citizens. And Vermont is not alone in having such a law or having such a database. In fact, there are 16 states that have or are in the process of creating databases along these lines. So the litigation in this case arises from Vermont's sending a subpoena to Liberty Mutual for its healthcare data, the data that Liberty Mutual is required to provide. And Liberty Mutual refused to provide the data. The matter goes to court, and it gets up to the U.S. Court of Appeals for the Second Circuit. And the Second Circuit held that the Vermont statute was preempted by the federal ERISA statute. ERISA is the Employee Retirement Income Security Act of 1972, and it's the federal law that governs employee health benefit plans and retirement benefit plans and the like. And ERISA contains a very broad preemption provision, which essentially says that any state law relating to an ERISA plan is preempted. And the Second Circuit, in a split decision, a 2-to-1 decision, said that that the Vermont Healthcare Database Statute intruded upon core areas of concern to ERISA, namely the reporting of healthcare data. And the Second Circuit also found it significant that, in its view, the Vermont statute was burdensome and time-consuming to comply with. So this is a case the Supreme Court has agreed to decide. The Obama administration has weighed in. The Justice Department actually has filed a brief supporting the state of Vermont. So the administration's view is that these database statutes are not preempted by the federal ERISA law. So this term we'll find out whether the states may, in fact, compel plan administrators and insurance companies to submit, reams of healthcare data, or whether such state laws are preempted under the ERISA statute. So turning now to the three cases in the pipeline I want to talk about, they all share a theme of in that they involve cross-border transactions or disputes arising out of our global economy. And I think it's not surprising that as the economy becomes more and more global, you'll see legal issues come to our courts that have global questions about them. So the case of RJR Nabisco versus the European Community is about the federal RICO statute and what is the geographic scope of the RICO statute. And this case, which again is pending on a petition for cert, we expect the Supreme Court to say yay or nay on whether they will review the case, within the coming days. This case also involves the doctrine of extraterritoriality, and that is the doctrine that federal courts use when they're trying to figure out whether an act of Congress, a federal statute, has application beyond the United States overseas to things occurring in foreign countries. And this is also a case in which the Washington Legal Foundation has filed an amicus brief urging the court to grant review. So that's a strong signal to the court that this is a case that's very important to the business community. So in applying this presumption, this doctrine of extraterritoriality, and it is a presumption, Congress, the Supreme Court has said, certainly has the power to say this law applies not only here but overseas. But it's a presumption that unless Congress speaks very clearly about what its intent is, federal courts will assume that the law was only meant to apply domestically. So, for example, if Congress passed a statute that said, American workers are not required to work on Sundays unless they wish to. If that's all the statute said, an American court would probably say, well, that applies to anyone working within the borders of the United States, but even if you're an American working for an American company overseas, that law wouldn't apply to you because Congress didn't specify that it applies overseas. So turning to the RJR case itself, it involves the RICO statute, which is the Racketeer Influenced and Corrupt Organizations Act. And this is the federal law that's aimed at organized crime and organized criminal activities. And to oversimplify matters, RICO makes it illegal for an enterprise to engage in a pattern of racketeering activities in violation of federal law. And importantly, RICO is not just a criminal law, it certainly is that, but it's also a civil statute. So private parties, private businesses can bring civil suits under RICO against other businesses, other corporations. And in fact, RICO is favorable in that sense to plaintiffs because it allows for, among other things, treble damages. So if you prevail in a RICO suit, you recover not only for the injuries you've actually suffered, but you get that by a multiple of 3. So pretty good if you're a successful RICO plaintiff. So in the RJR case itself, the suit was brought by the European Union and 26 of its member states who filed suit in federal court in New York against the R.J. Reynolds Tobacco Company and affiliated companies. And the European Union alleges that the RJR companies and affiliates conspired with cigarette wholesalers in countries like Colombia and Croatia to launder the proceeds of illegal narcotic sales in Europe. So these are pretty dramatic allegations and certainly have not been proven at this stage of the litigation, only alleged. And the Second Circuit was faced with the question whether this federal statute RICO applies to conduct overseas by foreign enterprises where the injury was caused in foreign lands. And the Second Circuit said yes, it does. And that holding really goes against the grain of all the other courts that have considered the issue, which have held that in their view, RICO only applies to domestic conduct within the United States. So this is a very important case on the question of the reach of the RICO law and how the presumption against extraterritorial application of U.S. laws applies to that statute. So that's one to watch, and should find out pretty soon whether the court will take that case. The next case I wanted to mention, and I'm cheating a little bit here because this case hasn't yet reached the United States, but it's part of the theme of extraterritorial application of U.S. law. I wanted to mention the Microsoft versus United States case. And this case is also, it's in the Second Circuit right now, and it was just argued there. And this is a case about whether the federal government can compel Microsoft to turn over emails and electronic information that it has stored on servers in Ireland. The U.S. attorney in New York gave a subpoena to Microsoft for communications between certain email addresses, and Microsoft's response was, well, look, these emails aren't here. We've got them in Ireland, and although there is a federal statute, the ECPA, the Electronic Communication Privacy Act, that says, generally email communications are private, but there's a carve-out for subpoenas. Microsoft's argument is look, the subpoena carve-out it doesn't make clear that it would apply to emails served on a server, stored on a server in Ireland. So under the presumption against extraterritoriality, you would construe that subpoena power only to go to emails that we have stored here in the United States. So this seems like a case that's could well end up in the Supreme Court, but for now at least it's still in the hands of the Second Circuit. But this is definitely a case worth monitoring, and you could easily see someone talking about this case at this panel this time next year. So the last case I wanted to mention, and continuing with the theme of cross-border transactions, the global economy, this is a petition for cert And full disclosure here, filed by my law firm along with another law firm, and it involves the foreign tax credit statute, and it also concerns a legal doctrine known as the economic substance doctrine. So the foreign tax credit statute, basically says that if a United States company pays income tax to a foreign country, then that U.S. company gets a tax credit in an offsetting amount so that the same income is not taxed a second time in the United States, because what a disincentive it would be to do international business if you got taxed on the same income twice. So America has this foreign tax credit statute. And in this case, the BB&T company, a U.S. corporation, entered into a transaction with Barclays. And this was a complicated transaction, complex enough that they gave the whole thing a name, STARS, the Structured Trust Advantaged Repackaged Securities Transaction. And although complicated, I'll just mention a few of the key elements of the transaction. There was a $1.5 billion loan from Barclays to BB&T. A trust was formed in the United Kingdom to which BB&T contributed some $6 billion in assets. And the transaction also obligated Barclays to make certain annual payments to BB&T. And pursuant to this transaction, over a 5-year span, BB&T ended up paying some $500 million in income taxes to the government of the United Kingdom, owing to the fact that this was a cross-border transaction. And so back in America, BB&T reported this income and claimed a foreign tax credit. And the IRS said no. Even though the IRS agreed that BB&T had complied with all of the statutory and regulatory requirements for claiming a foreign tax credit, the IRS was of the view that this very complicated transaction was entered into basically for the only purpose of engineering foreign tax credits. So the case ended up in court and gets up to the Court of Appeals for the Federal Circuit, and that court sided with the IRS, and it applied what it called the economic substance doctrine, which is a judge-made doctrine that courts have applied for a long time in helping to construe terms within the federal tax laws. And the Federal Circuit essentially agreed that this transaction was, although it involved billions of dollars moving around, they thought it was something of a sham and was put together in order to get these tax credits. The Second Circuit, after the Federal Circuit rendered its decision, the Second Circuit came along in a similar case involving the same kind of transaction, the STARS transaction, and sided with the Federal Circuit. But both courts acknowledged that their decisions were in conflict with other circuit court decisions. And so my firm has filed a petition, only yesterday, in fact. This case is styled Salem Financial versus United States, and it's one we'll be watching, and hopefully it'll be one that the Supreme Court decides to take up. But so with that, I'll turn this over to Linda.
Well, I want to thank the Washington Legal Foundation for having me here. It was a really nasty weather last night in Chicago, on the flight between Chicago and Washington, so I'm glad today is a little bit nicer. I understand you all got deluged while I was trying to land. It's always a trick to preview a term after a real blockbuster term, and I think it's hard to imagine a Supreme Court term in recent memory that was more of a blockbuster and that really got into more of the personal and public and political issues of our time than last term. And I always wonder when a term like that ends, if the Supreme Court justices are sitting around saying, wow, we're tired. Let's just do administrative law for a while, shall we? But it does look like there are going to be some interesting things this term. It is the 10th year of the Roberts Court. Justice Roberts took his seat yesterday, so it is his 10th anniversary. There are going to be some very interesting and I think high-profile cases this year. The Fisher case is one of them, dealing with affirmative action in higher education admission. There may be an abortion case for the first time in several years. There may be some redistricting and voting rights cases, which is not unusual as an election approaches. And there are some good business cases, and that's what we're here to talk about today. I'm going to talk about a couple of cases that deal with securities and with arbitration, two issues that are of great interest to a lot of business, to the business community in general. First of all, Merrill Lynch versus Manning, or Menning, I should say. This is a securities regulation case, but it's really about federal jurisdiction, and I think it is a case that federal jurisdiction geeks will love. The case involves some financial institutions, Merrill Lynch and E-Trade, and a few others who were sued in New Jersey state court by some plaintiffs claiming that they had engaged in naked short selling. And what that means is selling stocks that the defendants didn't actually have at the time. They didn't own the stocks, they hadn't borrowed them, they just sold them and then bought them back at a lower price. That's called a naked short sale. And the case is based on state law theories, but the underlying allegation is that these defendants violated Reg SHO, which is a federal securities regulation that regulates short selling. The defendants removed the case to federal court, and the district court ruled on a motion to send it back to state court and said, nope, this case should stay in federal court. And the court relied on Section 27 of the Exchange Act of 1934, which provides that federal courts shall have, I'm quoting, shall have exclusive jurisdiction over violations of the act or rules of regulations and of all suits in equity and actions at law brought to enforce any liability or duty under the rules and regulations. So that sounds like an exclusive jurisdiction provision to me, but the district court relied on that and said, yes, the case shall remain in federal court under the exclusive jurisdiction of the federal courts. The district court, though, certified an interlocutory appeal to the Third Circuit, and the Third Circuit reversed and said the case should go back to state court. It held that Section 27 isn't a statute that grants jurisdiction. It doesn't actually give power to the federal courts. All it does is deprive state courts of jurisdiction if federal jurisdiction would exist under some different statute, like Section 1331, which is about federal question jurisdiction. And the briefs in this case are really much more about the history and statutory basis of federal jurisdiction than they are about securities regulation. And I think that it's that history, that context of jurisdiction that will drive the outcome of this case. Now, for jurisdiction geeks, this grant of certiorari also is interesting in one other way. It shows once again that an appellate decision sending a case back to state court can be reviewed by the Supreme Court. There's a statute that says, that 1447D, that says that decisions to remand a case to state court are normally not reviewable. I handle a lot of remand and removal issues, and I've heard plaintiffs argue that once a court of appeals issues a decision that sending a case back to state court, that decision can't be reviewed anymore. But this is a case that the Supreme Court has accepted for review. And it shows once again that the Supreme Court gets to review these cases if it likes, and its jurisdiction is not limited by that non-appealability provision. Turning to arbitration. In the October sitting, we're going to hear arguments in DirecTV versus Imburgia, and this is a case where the Washington Legal Foundation filed a brief, both in support of the petition for certiorari and on the merits. As you know, there's been a dance going on for many years between the state of California and the federal government in respect to arbitration. The Supreme Court and the Congress have expressed a preference for arbitration, and the Federal Arbitration Act says that an agreement to arbitrate has to be enforced just like any other contract. The state courts of California have had a very long series of decisions pushing back against that. There's been a long-standing policy in California to not enforce arbitration agreements, a preference for in-court resolution. And in a long series of cases, the Supreme Court has really pushed back on that. The DirecTV case is another one in that line. Now, a lot of people thought that this dance was over in 2011 when the Supreme Court issued its decision in AT&T Mobility versus Concepcion. That was about a California rule saying that arbitration clauses aren't enforceable unless they provide for class-wide arbitration. And the Supreme Court said that that rule was preempted by the Federal Arbitration Act. Essentially, the court said, it's a very interesting decision, essentially the court said that the FAA, the Federal Arbitration Act, authorizes arbitration, and class arbitration proceedings really wouldn't be arbitration in the sense that we think of arbitration. You need all kinds of procedural protections and so forth for a class action that just can't be relied on in arbitration. And so that's really the broadest pro-arbitration decision we have from the Supreme Court yet. In this case, the DirecTV case, the California Court of Appeal held that a waiver of class claims was unenforceable because the parties had agreed in the contract that in respect to class arbitration, the arbitration agreement would be governed by state law rather than the FAA. Now, there's a real question about whether the contract actually said that. What the contract said was that issues of contract interpretation would be governed by the law of your state. Now, that's actually typical. Usually contracts, like arbitration contracts, are governed by state law and interpreted under state law. But the contract also had a non-severability clause that said that if state law would refuse to enforce the class action waiver, then the whole arbitration clause was unenforceable. And the California Court of Appeal read that to refer to state law and to choose state law in terms of deciding whether a class action waiver would be enforceable. The Ninth Circuit had a case where it actually reviewed the same contract and said, no, it doesn't say that. What it means here, what this contract means is actually the parties really didn't want to do class action arbitration. That's why they had this severability clause in there. And to enforce that consistent with their intent, we need to enforce the contract as it's written. So this is actually a pretty unusual situation. The state court below resolved this case based on what may be one court's misreading of a specific statute. Now, that's pretty unusual. Usually that would lead the Supreme Court to conclude, well, this decision might be wrong, but it's not a good candidate for certiorari. I think the court, and it's interesting, if you look at the briefs on the merits in this case, Tom Goldstein took on this case at the merits level and filed a brief, and he's representing the respondents, and he's actually arguing in the alternative that the case should be dismissed as improvidently granted for this reason. I think the court knew what it was doing when it took this case, because this issue of contract interpretation was well laid out in the briefs. I think the court was persuaded that it needs to reaffirm Concepcion again, because the California courts again and again seem to be pushing against it. And I have to say, I'm personally, this is just me speaking, but I'm personally not feeling a great deal of suspense about how this particular case is going to come out. Now, this is not the only California arbitration case that may be hitting the court this year. There is another case pending called MHN Government Services versus Zabrowski. It's a petition for cert pending. This one also deals with a similar kind of rule. There's a California rule that you apply one rule of severability for ordinary contracts, and you apply a different rule of severability for arbitration agreements. You can guess that the arbitration-only rule of severability disfavors arbitration. So the question is whether that different rule for arbitration is preempted by the FAA. It's a pretty interesting issue. It actually reminds me a little bit of a case that was before the court last year, the M&G Polymers case, which was about a special rule of contract interpretation that had been adopted by the Sixth Circuit specifically to apply to collective bargaining agreements. And the Supreme Court said, no, we're not going to do that. A collective bargaining agreement is a contract. It's a contract that's contemplated by this important federal statute, but we're going to interpret those contracts under regular rules, ordinary rules of contract interpretation. It's kind of a similar idea coming up in this case, where California has a special rule that just applies in the arbitration context. Now, obviously, there are differences in the situations, and you don't have quite the same preemption issue coming up. But that M&G case does suggest to me that the Supreme Court is inherently suspicious of jurisdictions adopting special contract rules to put the thumb on the scale on one side of an issue on which there is a federal statute with a federal policy at stake. There are two other California arbitration cases that have petitions pending. One of them, the Carmax case, has to do with whether the California Supreme Court's Iskanian rule is preempted by the FAA. That's a case in the California Supreme Court that held that a private attorney general action was exempt from arbitration and from the FAA. Then there's Applied Underwriters versus Arrow, which is about whether a generic choice of law provision in an otherwise broad arbitration contract should be read to reflect an intent to avoid preemption under the FAA. So again, these are another set of California cases raising arbitration questions. One possibility is that these are petitions that are pending. A response has been requested. My guess is that these cases will probably be held for the DirecTV case, but I think we can look for some kind of action by the Supreme Court on those kinds of cases as well. There's one other pending case on cert that I want to mention. It's another securities case. It's called U.S. versus Newman. It's coming out of the Second Circuit, and it's a really sexy case about hedge fund managers who were accused of and convicted of insider trading. There was a whole sting, and they were arrested in their offices, and it was quite a drama. The issue in this case relates back to a decision in 1983 called Dirks. Dirks recognized that disclosing insider info and even trading on inside information isn't necessarily illegal. It's illegal if the insider or tipper made the information available improperly. For example, when they're getting a personal benefit for doing it, they're selling it or benefiting it somehow from disclosing that information. And if the person who's trading on the information knows that the information was disclosed in breach of the tipper's fiduciary duty. The Dirks case said that a tipper can obtain a personal benefit if they make a gift of confidential information to a relative or a friend. Now, in Newman, the Second Circuit held that you can infer that kind of personal benefit only if there was a meaningfully close personal relationship between the tippee and the tipper, and if that disclosure of information produces an exchange that is objective and consequential and represents some kind of pecuniary gain or value gain to the tipper. So the United States, the Solicitor General, filed a petition for certiorari, and he's arguing that the decision was an impermissible gloss on Dirks. It created a circuit split, and that this ruling is now hindering law enforcement efforts. And that by itself might be a pretty strong, you would think that's a pretty strong reason to expect a grant of certiorari, especially with the Solicitor General on the petition. But there are also some interesting and decent arguments against a grant of cert. Now, as you might expect, the respondents are arguing that there was nothing wrong with what happened here, that there's no circuit split, and that this case is really just about whether this evidence is sufficient to show insider trading. But there's also this argument that the outcome of this benefit question isn't going to make a difference for Mr. Newman and his compatriot. And the reason is because they were actually remote tippees. The information passed through multiple hands before it got to these alleged inside traders. And so the argument is that there isn't enough evidence that they knew about the impropriety in any event. So there does seem to be, if you look at the papers, there does seem to be a real disagreement about what Dirks means, but there's also a real disagreement about what the record shows. And I think the question is going to be whether the Supreme Court can get past that factual disagreement and identify a set of facts on which to decide the case that would make an outcome determinative difference. You know, in the end, the Supreme Court likes to decide issues when the issue in that case will make a difference. That's actually part of its requirement, to decide cases that matter and not to issue advisory opinions. So I think it's going to be interesting to see what happens with that petition. That is one of the petitions that we expect was actually considered and decided by the court on Monday, and we should be getting a ruling on that petition later this week. Tom?
Thanks, Linda, and thanks, Glenn, and again to the Washington Legal Foundation. It's a privilege to be here and participate in the annual fall Supreme Court sweepstakes discussion, as Linda said. I'm going to be talking about an area that's near and dear to my heart, class actions. And in that area, this is one of those terms in which there seems to be something of a theme to the cases the court has granted review in. You might call it the term of the uninjured class member. The court has, at present, 3 cases that present different variations of that theme already on its merits docket. First, in the Spokio case, the question is whether Congress can confer standing to sue on uninjured plaintiffs in a class action, effectively outsourcing government law enforcement efforts to private parties simply by creating a cause of action for private parties to bring an action to enforce a federal statute in the absence of any direct personal injury caused by the defendant. This particular case involves Spokio, which aggregates information on the internet about all of us, and then sells it to interested businesses that are trying to compile address, phone number, email, and other information about individuals. This action was filed by class action plaintiffs' lawyers on behalf of an individual who says that Spokio's information about him was inaccurate and that Spokio also failed to comply with certain procedural requirements, and that the action is based on the Fair Credit Reporting Act, which goes by the mellifluous acronym FCRA. And it's, although there's a bit of dispute, or at least the plaintiff eventually tried to raise a dispute, the courts below decided the case on the premise that the plaintiff was not actually injured by these technical violations of FCRA, but he nonetheless is seeking $1,000 per violation in statutory penalties for each violation, and the money to be payable not only to himself, of course, but to potentially millions of class members. The point being, of course, that dramatically increases the fees available to the plaintiff's lawyers bringing the class action. I should note here that this particular plaintiff is apparently a remarkably humble man, because the alleged inaccuracies in the Spokio information that he's complaining about are essentially that, according to him, Spokio inaccurately exaggerated his qualifications, work experience, wealth, and so forth. So the district court was unmoved by these alleged falsehoods and dismissed for lack of standing. The Ninth Circuit reversed, holding that notwithstanding the absence of actual injury to the plaintiff is not required to establish standing as long as Congress has created a statutory cause of action that confers a statutory right, and the plaintiff is claiming that this statutory right has been violated. There's no requirement that the plaintiff actually be injured as long as Congress didn't include such a requirement in the statute. From a constitutional standpoint, this creates a problem under Article 3, which limits the scope of the judicial power and therefore the authority of the federal courts to hear cases to actual cases or controversies. And the Supreme Court has made clear over the years that this means that any plaintiff seeking to invoke the power of the federal courts has to have standing, and the irreducible constitutional minimum for standing under Article 3 is injury in fact, which means that the plaintiff has to be suffering from actual or imminent harm that is concrete and particularized. The mere fact that a plaintiff is unhappy with what a defendant is doing is not enough to invoke the power of the federal courts to decide what federal law says about that. And this constitutional requirement serves important separation of powers functions, as Washington Legal Foundation explains in the amicus brief it filed in this case, by preventing Congress from essentially delegating to private powers the authority of the executive branch to enforce federal law. And, of course, executive branch officials in the enforcement of federal law are subject to various constitutional constraints and also practical constraints, like they only have the resources that Congress has chosen to give them, and they have to exercise enforcement discretion to bring cases that are most appropriate in light of their limited resources. But Congress can essentially get around all of that and eliminate those protections if it can delegate to private parties the ability to enforce any federal statute it wants, even when they lack no direct personal stake in the outcome other than whatever bounty Congress has chosen to hold out as an incentive for them to bring these actions. If that is the law, we've moved very far away from the governmental structure of checks and balances that the framers thought they had created. And we'll find out the answer to that question later this term. The second case I want to talk about is called Campbell-Ewald against Gomez, which presents a different aspect of this big picture question or problem of the uninjured class member. In this case, the plaintiff sued a military contractor, a military recruiting contractor, for sending him a text message which said and invited him to, quote, get a career, an education, and a chance to serve a greater cause, close quote, by joining the Navy. Apparently this offended him. His brief explains that at the time he received the text, he was nearly 40 years old, much too old to join the Navy. And he also claims that the text violated one of the class action plaintiff's lawyer's favorite statutes, the Telephone Consumer Protection Act, which I guess is called TICPA. I'm not sure if people actually call it that. and in any event, he sought, again, statutory penalties of $500 in this case under the statute per text sent to him and, of course, every other member of the class. Congress, again, having created these statutory penalties regardless of any actual injury, presumably in order to incentivize lawsuits, since the government is too busy reading our texts to bring lawsuits against wrongful text message senders. So I guess receiving an unwanted text message that implies you're younger than you really are is more of an injury than information being disseminated about you that describes you as more experienced and more qualified and wealthier than you actually are, because the issue in this case is not whether the plaintiff has any injury from the get-go. Rather, what happened in this case is that before the class had been certified, so that when only the individual plaintiff was technically a party at that point, Campbell-Ewald, the defendant, made a formal offer of judgment offering to pay the plaintiff $1,500, actually $1,503, more than triple the amount of the statutory penalty for any text he allegedly received in violation of the Act, plus his costs, and also and agree to an injunction, basically saying, we'll give you everything you're asking for and more. The plaintiff refused the offer because, of course, the whole point of the action is not that the plaintiff actually wants the money, it's that the class action plaintiff's lawyers want the millions of dollars they would get from the settlement. And so Campbell-Ewald moved to dismiss the action for lack of standing on the ground that at this point, having already been offered everything he could possibly hope to achieve, there's no case or controversy remaining. And the district court actually disagreed with that, but dismissed on a separate ground about on the theory that this was essentially a sovereign act and therefore the contractor was entitled to the immunity of the Navy. The Ninth Circuit reversed on both grounds, and with respect to the issue that we're interested in here, they essentially said that since the offer hadn't been accepted, the dispute was still alive, and therefore there was an ongoing case or controversy for the courts to adjudicate. So the Supreme Court now has the opportunity to decide first whether an unaccepted offer of complete relief moots the claim of an individual plaintiff who has just, for whatever reason, chosen not to accept that offer. And then secondly, if it does that also moot the class action in circumstances where the class action has not yet been certified? The court has said in other cases that once a class is certified, you've got the class itself as an independent, legally cognizable entity, and the fact that a named plaintiff may lose standing doesn't affect the ability of the class to proceed. But here, where the class has not yet been certified, that question is unanswered. There's substantial support in Supreme Court precedent for the notion that an offer of complete relief to the plaintiff moots the plaintiff's claims, even if the plaintiff, for whatever reason, chooses not to accept it. And that doesn't seem particularly surprising, at least not to me, because the courts have always been clear that parties can't sort of artificially manufacture disputes that give rise to standing just because they want to get a ruling from the courts on some federal law question that they want to know the answer to. There has to be a real, live, actual controversy, and if the claims, everything the plaintiff is asking for has been satisfied or the defendant has offered to satisfy it, there's not really a real, live controversy over the underlying dispute at that point. It's really just a sort of an artificial question of law that they want the courts to give an advisory opinion on. The plaintiff has some arguments here that that's not really what's going on, that really he wants his attorney's fees, so that it wasn't the full offer of relief, although, of course, the attorney's fees would go to the attorneys, not the plaintiff, so it's not clear how that really affects things. He also claims he has independent interests as a class action plaintiff that should somehow be factored into the equation. So it'll be interesting to see how the court resolves this. Of course, probably the principal objection he raises, and that actually has been discussed from varying perspectives and with varying results in prior cases, is kind of the practical objection that if defendants can moot a class action plaintiff's claims before certification of the class by making such an offer, then that makes it harder to bring class actions and get classes certified, at least in cases where the amount in controversy for any given plaintiff is very small, because it's easy for the defendant just to pay the plaintiff, resolve the dispute, and then you have, from the class action plaintiff's lawyers, their client should be happy, but they're not happy because they have no case to proceed to try and get certified, which then dramatically increases the settlement value. This case could have a significant impact in terms of reducing the litigation costs that defendants face in class actions on behalf of claimants who have no significant injuries. Obviously, if it's some big antitrust class action or a securities class action where the named plaintiffs actually have sizable individual claims, it's not going to be much use because presumably the defendants don't want to pay 100 cents or more than 100 cents on the dollar for claims that they typically want to dispute, only to have more plaintiffs line up and ask for the same chunk of change. But it will, again, in the kind of the classic consumer class action where the individual plaintiffs are allegedly injured to the tune of a few cents or dollars, it will, if nothing else, it will dramatically increase the what you might call the research costs for the plaintiffs' attorneys' firms. It kind of changes their business model because they invest resources in trying to find named plaintiffs so they can bring their actions. And if their named plaintiffs keep getting all the relief they seek and they have to go find more, it makes things more difficult. Thirdly, and in my view, perhaps the most important of these cases, at least from the perspective of the cases that I tend to work on, there's the Tyson's food case. And I should mention, my firm filed an amicus brief in the Tyson Foods case and also in the Campbell-Ewald case. So Tyson involves a Fair Labor Standards Act claim, a wage and hours claim, for overtime pay on behalf of Iowa pork processors who claim that they spent more time donning and doffing, putting on and taking off their equipment for working in the slaughterhouse than they were paid for. And And again, of course, in order to make this pay, it had to be brought as a class action and a collective action under the PLLC. But the problem for the plaintiffs' lawyers was that there's actually huge variation among the 3,000 or so class members in terms of how much time they spent donning and doffing their equipment, what kind of equipment they donned or doffed, and how much they were paid for it. So trying to litigate all these individualized issues in a single trial, which is the point of a class action, of course, would have been essentially impossible. So what the plaintiffs did, and this is actually quite common these days, is they just hired an expert to do a statistical analysis and figure out average times for donning and doffing. And then they hired another expert to take those averages and calculate compensation for the class as a result of, if you assume the average person spent this many minutes and was compensated on average this much, then their damages would be this, and then apply that to the individual time records of the individual plaintiffs to come up with a number. And the lower courts said that this averaging process is perfectly kosher, and notwithstanding the pork processing nature of the claim, the jury found for the plaintiffs, although it awarded only a few $1 million, so you could say the plaintiffs' lawyers were not exactly in hog heaven. Sorry. Tyson took the case to the Supreme Court, arguing that it's totally contrary to the basic principles of class action law, which is designed to try common issues that are common to the class, to base a class trial on these the hypothetical average plaintiff, which of course doesn't actually exist in practice, and thereby gloss over all the differences among the class members and prevent the defendant from raising all the individualized defenses that they would have if you were actually going to look at each individual member of the class and their very different personal situations. In theory, the law is clear that class actions are only supposed to resolve common issues and can't deprive defendants of their right to raise individualized defenses, but in practice, as this case illustrates, that often goes by the wayside. In fact, in this case, and this may be one of the reasons why the court took this case, the situation is particularly stark because Tyson pointed out that even under the plaintiff's own expert evidence, it's clear that more than 200 of the class members had no injury at all. And yet the jury was just asked to award an aggregate dollar amount to the class as a whole. And the reason why I say this is particularly important is because, as I said, how common it is that you have, as the attractiveness of class actions has become increasingly clear, you have people trying to push the boundaries of the class action doctrine, the class action mechanism to expand the scope of actions that can be brought. And they use this statistical averaging method to try and gloss over any variation among individual class members. You see this in antitrust cases and in employment cases in particular. You've always got the plaintiffs hiring an expert or two to come in and try and address these issues. And in fact, in the past several years, the Supreme Court has repeatedly denied cert in other cases raising this same sort of issue in the class action context. 3 of those petitions were ones that I worked on, not that I'm bitter or anything. So in my view, it was high time that the court take the issue. If the court does reiterate the principles that are supposed to govern class actions and overturn this class, it may therefore have an impact in the lower courts going forward in the category of class actions where there really is a lot of variation among the class members in terms of their claims. Now, obviously, not every class action fits that bill. In some types of securities class actions, for instance, there may be essentially no real individualized issues other than just the mechanical question of calculating damages if the class can prove that there was a securities fraud. That's not always the case, but in some cases that may be true. But in other cases, there are going to be too many individualized issues if you're going to actually preserve the right of the defendant to raise individualized defenses and require the class definition to exclude uninjured plaintiffs. It may be impossible to certify a class. I have my doubts, though, that even if the court does that, that the lower courts will start towing the line on these principles, because there seems to be a sense in many lower courts that the class action device is just too attractive. It's so efficient. We can just resolve these cases in one fell swoop instead of potentially having hundreds or thousands of lawsuits. And why do we have to worry about these pesky details like whether the defendant's right to raise individualized defenses is actually being preserved? And frankly, from my perspective, the Tyson Foods case may actually be too easy. It seems to me that there are so many problems with the class that was certified here and the way in which the plaintiffs proceeded with this relatively unsophisticated averaging method. Other plaintiffs' lawyers have more sophisticated experts and try and do a little more precise job, but essentially still averaging across the class. So depending on how the court resolves it, it may not fully resolve these problems. Do we have time for more, or should we close? All right, let's do questions. So those are the merits cases. There are some cert petitions pending that raise class action issues as well, but of course we don't know whether the court's going to take those or not, and they may feel they've got enough class action work on their docket for this term. Thanks.
Should also note that Tom's partner, Ted Olson, and one of the associates at Gibson, Dunn, Lucas Townsend, have done an excellent paper for Washington Legal Foundation on the 3 cases that Tom was talking about, and that is available on our website. Certainly encourage those of you who are online to check that out. We'll do questions if you are online. Again, I want to remind you that you can send in questions to interactive@wlf.org. If anyone in the studio audience here has a question, you'll be handed a microphone, which is for the benefit of the online viewers, not to elevate your voice. Any questions from any of our people in-house? Yes.
Hi, my name's Elaine Middleman. From Mr. Hungar, I was going to ask you what you raised just at the end there. Is there a vehicle for challenging the experts? Because it sounded like you were saying their methodology was maybe suspect in terms of just coming up with an average.
Yeah,
I mean, is that an easier thing to do than?
Depending on the case and the court, obviously, yes. I mean, here, and as I say, that's one of the reasons why this case may be too easy, because there are grounds for challenging what the expert did. Like he didn't have any sort of a rigorous random method for determining which employees he looked at to develop his averages. He just kind of showed up at the plant, watched for a while, took some video, and counted how long it took for the particular plaintiffs he happened to watch to don whatever it is they donned and doffed. So yeah, and that often that's the fight in the class action cases, is challenging the experts. But it's a difficult standard of review. So if the judge at the trial court level allows the expert in, it's a difficult standard of review on appeal. So often the stronger appellate arguments are going to be these broader class action issues.
I was just absorbing the observation that a case may be too easy for the Supreme Court, but a Court of Appeals got it wrong.
Yes. Well, it was a split decision in the Court of Appeals.
There's an online question for Linda, and I'll paraphrase. Since the lower court decided the DirecTV arbitration case, the California Supreme Court has come out with some cases that have been more responsive to the Supreme Court on issues like unconscionability. So the question is, if the Supreme Court were to dismiss as improvidently granted the DirecTV case, would it undermine the progress that seems to be being made in California or not?
Well, that's a really good question, and it may well undermine that progress. The court could decide, to some extent, the court is a little bit immune from that kind of thing, right? It's going to actually look at this petition and say, does this petition allow us to decide this issue? And if the court dismissed as improvidently granted, it may be just because the court is concluding that it does not have the record that enables it to decide the issue. But it does seem clear that the court is taking all these California cases because it's gotten a little frustrated with this constant battle between the state of California and the Federal Arbitration Act. And so, perhaps they would consider that. I'm actually not sure how closely the Supreme Court is following that. So it's going to depend on whether the parties really make that argument. Because I'm not confident, actually, that the Supreme Court is monitoring today what's happening in the California Supreme Court. The court really decides the cases that are brought to it.
There's another online question that would be open to any of you, which is the court recently seems to have granted cert in one or two cases each year from the so-called outrage docket. Are there any candidates pending right now or any cases you're aware of that have been granted that you would put in the category of being from the outrage or for the outrage docket?
Not sure what the outrage docket is.
Well, the example that we've heard before is like the Yates case, for example, of the fisherman who threw fish overboard and was charged under Sarbanes-Oxley for shredding documents. I think the Bond case with the chemicals on the doorknob has been sometimes attributed to that category. So a case that you wouldn't necessarily think the court would grant cert on. Maybe there aren't any this term, but I just wanted to throw that question out.
Well, there are certainly cases, and you've heard about some of them here today, that present such an kind of outrageous set of facts or such a clear set of facts that you wonder. But I think, and I would actually put DirecTV in that category. I would, some of these no injury cases might fall in that category because you're thinking, really, is the guy injured because of what Spokio said? And we're waiting to see about those. But I think that the court is always looking for the cleanest set of facts to resolve the case on. And so it's actually sometimes going to be just taking cases that have a particularly clear-cut set of facts because that's actually the best case in which to resolve a legal issue. So it's a little hard sometimes to identify which ones are being taken just because of outrage. I actually think there are probably fairly few that are taken just because the facts are so outrageous. The court has a lot of systems in place to really prevent it from doing that.
Further questions? Yes.
Richard Samp, I have a question about you were talking about the Campbell-Ewald case. There certainly is a concern that if a defendant can moot a case by paying off an individual defendant, that's going to make a lot of cases that would otherwise go forward go away. And one that comes to mind is the Fisher case involving the University of Texas Affirmative Action Program. If I gather the only injury in that case is the plaintiff has already graduated from another college and she wants a refund of the $50 application fee that she submitted. What are the practical limits of a decision if Campbell-Ewald wins this case? What would stop lots of cases like that from being mooted out, and where the case clearly isn't being brought for the small amount of money at issue, but rather is being brought, say, by the National Right to Work Foundation to support the rights of individual workers not to join unions, or of somebody who doesn't like an affirmative action program but has already graduated from college?
Well, so in some circumstances, and the cases like the one you described may be in this category, there's the capable of repetition but evading review doctrine, and a related doctrine that they've applied in the class action context specifically, where and part of the injury in an affirmative action case is the denial of the right to have your application processed according to the standards that you think should apply. And even if your monetary injury were taken away, there are other plaintiffs in the pipeline, and there may be a kind of a capable of repetition analysis. I think, though, when a case is really just about the money, and it's on behalf of a class of consumers, I mean, what the court could say, assuming it holds here that there is no standing and that the case is moot, I mean, as a practical matter, any consumer who actually is unhappy with what has been done, they can file their own lawsuit. And if 10,000 or 100,000 consumers do that, the defendant is going to be faced with either buying each and every one of them off, in which case every consumer who cares enough to bring a lawsuit is going to be vindicated, or is going to have to proceed to litigate the case. And so I think as a practical matter, probably the impact of this is really going to be only in those cases where where really nobody cares except for the plaintiff's lawyers.
I also wonder if there's going to ultimately be a rule change that deals with this issue. Because at the end of the day, it's a practical problem, right? As soon as the class is certified, if a class is certified, we know that you can't moot the case by settling with the lead plaintiff. If the class isn't certified, well, then it shouldn't be a class action. You should be able to moot the case by settling with the lead plaintiff. So it's really a procedural problem, if you think about it. In the Seventh Circuit, until just a couple of weeks ago, there was a practice in place where there was a case called Damasco that was decided a couple of years ago that dealt with this very question. And it said that as soon as the class certification motion is filed, then you can't try to settle with the named plaintiff. You have to wait till class certification is resolved. You can't try to buy off the named plaintiff. And the reason that existed was for this very practical purpose that you've mentioned. That was called the Damasco case. And so there was a practice in the Seventh Circuit of the parties entering into a stipulation at the beginning of the case. When a plaintiff filed a class action lawsuit, they would file the motion for class certification on the same day to trigger that rule, to protect their class. And to get that motion off the docket so that no one has to report it to Congress that a motion's been pending for a year and a half, the parties would file a stipulation saying that the defendants agree not to try to buy off the lead plaintiff. Damasco was actually overruled just a couple weeks ago by the Seventh Circuit, where the Seventh Circuit said, you know what, we're just going to hold that settling with the named plaintiff in a class action does not moot the case, period. If there's some other relief, injunctive or whatever, that might have been obtained. Now, that decision was rendered by Judge Posner and Easterbrook and Judge Mannion. Is obviously going to be very short-lived because this is the question that's before the court right now. But I think ultimately there may be a procedural fix to this where somebody decides that there needs to be some kind of procedural mechanism to allow class actions to proceed, because I do understand the concern on the other side of this issue, which is that allowing an offer of judgment to moot the case makes it really quite difficult to pursue a class action in a case where it's mostly damages at stake.
I had one question I wanted to pose. There's an additional case that Washington Legal Foundation filed an amicus brief in support of the grant of cert that we're waiting to hear on. The case is Quicken Loans, Inc. v. Brown. It's out of the state of West Virginia. The issue is, in a nutshell, is that the West Virginia Supreme Court refused to overturn a trial court decision where the punitive damages awarded were many multiples of what is permissible under reigning U.S. Supreme Court precedent. And yet, in its opinion, the West Virginia Supreme Court asserted falsely that the defendant had not raised this issue or had not adequately addressed this issue. One only has to look at the briefs to see that the issue was emphatically raised over and over. And so if this one were granted, I suppose maybe it would be an example of something for the outrage docket, but I'm wondering if my question for the panel would be, what do you think the odds are that the court will grant a punitive damages, if not this one, some other punitive damages cert petition in this term or the near future?
Well, it seems to me that if the procedural ruling is that clear, that could be handled even with a summary disposition that sends it back and doesn't make too big a deal out of it or tries to embarrass a state Supreme Court. I think the court has remained interested in the constitutional limits on punitive damages, but I don't think that they have enough time on their docket to monitor each case in which the limits seem to have been blown past. So you probably need something a little more than that to get their attention.
One final question? Yes.
I want to share the love, so this is for you. It seemed like every case you talked about had international impact or effect or whatever, and I was wondering what you thought of Justice Breyer's book and his emphasis on international law.
Well, I have to be careful because I haven't read the book. I'm aware of it. It's.
Although I think my guess is that he would was hoping to talk a little bit more about the book than about cameras in the courtroom.
You know, I think this whole question about whether it's appropriate to look at foreign law in deciding American legal questions, I think the positions on both the left and the right get oversimplified. Like, I mean, conservatives, you know, love to look at old English law in deciding, you know, hoary federal statutes and the like. So in some contexts, yeah, everyone agrees it's appropriate to look at you know, foreign law. And I don't know that on the left that there's really an appetite to just look at any other country's law in deciding you know, a totally disconnected question of American law. But, you know, the globe is getting smaller, as they say. So I think it doesn't surprise me that you see the Supreme Court and lower courts looking at foreign decisions more when deciding American legal questions. I think
the real question, I mean, yeah, as Chris said, I think a lot of the debate is really on something that people don't really debate. You know, if it's a treaty issue or so whatever, obviously you're going to look to international law, to the laws of other jurisdictions. So there are plenty of circumstances where everybody on the court would agree it's appropriate to look to decisions in other countries, for instance. I think where the debate really is crystallized is on questions of construing the U.S. Constitution. And as Chris says, even there, since the U.S. Constitution is an outgrowth of Anglo-Saxon and particularly English legal doctrines, and the courts will look to that. But the question is it appropriate and relevant or not to say, okay, we've got this constitutional question about whatever it may be, the death penalty or gay marriage in the 21st century, does it matter in construing a U.S. constitutional document created in the 1700s what country X or country Y has to say about it? That's where the debate is, and I think, I mean, I have my own views on that. I think just one final comment on that. One problem that the conservative objectors raise is that it's a very malleable and inconsistently applied doctrine, right? If the people who favor looking to international law to construe the Constitution like what other courts in other jurisdictions have said, they look to it, and if they don't, they don't. And a case in point being, again, the gay marriage case, where the majority paid no attention to the fact that the U.S., as a result of this decision, is almost striking out on its own compared to the vast majority of other countries, and they say, well, that's irrelevant, or they didn't say it, but the implication is that's irrelevant here, but then why is it relevant elsewhere?
I think we'll wrap up there. There's a slide right now online that indicates a few upcoming programs that we have. 2 web seminar programs, one on the very topical issue of what's the definition of employer and employee, and what's the NLRB and EEOC and other agencies doing about that, and also things going on at the state level. And then the second one on emerging products liability risks issues with the so-called Internet of Things, connectivity of devices and such. I want to thank the speakers for joining us today, and thank everyone who joined us here and online.